world, 8% is spent on fine art and pictures and sculptures. And in India, 0.02% is spent on fine arts. So there is a lot of forgeries on this area, and $1 million worth of forged art is traded in India every year. Similar, coming to visual arts, theatre, we have the best traditional cultural expressions in our country, folklore, everything. Now, this is all known to us. How do we deal with it, and what are the issues that are facing our industry now? The biggest issue that I faced, even as a practitioner, was, I remember there were so many clients of ours who would come and ask, we want to buy and license a particular tune from a very old Bollywood song. Whom do we go to? And what do we pay? We want to do it legally, but where do we go? No one knows where to go. This is a big problem insofar as there is no one who tells us who is, the owner of a copyright, where is the place that we can, obtain rights, obtain licenses. The Copyright Amendment Act of 2012 brought various amendments for artists, lyricists, stakeholders, authors, music producers, everybody. But then I think collective management and collection of licenses, license fee and royalties for them has been a failure. It's been 10 years. I don't know why collective management doesn't work in India. It just doesn't seem to work. And that needs to be addressed. There are multiple stakeholders, multiple right holders. There is a huge supply and a huge demand, but there is no channel. There is a lot of copyright works on the one hand. There are a large number of people who want to exploit them, but how do you bring them on one platform? I do not see a solution coming up, because the industry needs to get together and create a solution with the government. Otherwise, we are in for a very big, long haul of lack of adequate revenues in the copyright space is what I feel. Some of the suggestions, even when I've attended international events, and for example, if you look at the WIPO platforms, etc., there are a large number of models that we can follow. And some of the models I want to mention, because I think we need to look at what we can do and how to solve this problem, because the laws are there. Doing forgery is wrong. Pirating is wrong. There are injunctions granted by courts every day. Judges recognize these rights very well. But that recognition becomes very, very singular for that particular work or that particular copyrighted, album or music or repertoire or playlist or whatever you may call it. It is not transcending across copyright works and across copyright owners, and ultimately the benefits are not coming, And some of the issues, some of the models which exist internationally are for having an, national enforcement agency on IP. That is one of the first things I think which we can look at, as there are several, I can give you examples of some agencies that exist. For example, in the European Union, there is what is called the Office of the International Intellectual Property Enforcement, IPE. This is in the US. Japan has IP border enforcement. Philippines has the intellectual property, which has an enforcement office within it. Uganda, Ukraine, Russia, even Pakistan has a separate IPR enforcement agency. Armenia, New Zealand, Canada, almost all the countries whom you check have separate agencies for IPR enforcement. And my own experience on the IP division tells me that the biggest challenge that IP owners are facing today is the online counterfeits, online violations, online piracy. There are and this is actually assuming very serious proportions. Now, there are a large number of matters which we on the IP division, we are 3 judges in the Delhi High Court, we face on a daily basis, and these relate to registration of fake domain names. And what is done is, the domain names are registered with 800 or 1,000 rupees, and then there's a whole ecosystem which is created, And there's a complete, if you may say, dubious manner in which these businesses are, imitated and cloned onto the website. And you will not believe, the Delhi High Court currently is dealing with at least 70 to 80 such suits where amounts have been collected on the ground of giving distributorship, franchiseship, copyright music being allowed to be downloaded, etc. Crores of rupees have been collected by these people. And we are, kind of getting it investigated by the cyber police. It is a challenge because none of us know who are the IPR owners. The cyber police is not aware who are the IPR owners. We don't know who are the victims, how much monies have been paid. They've all been collected into bank accounts. And this is a very, very big problem. Imagine 70 to 100 suits in one court on this particular issue. And this is the kind of challenge that we are facing. And therefore, I feel the time has now come to actually create India's intellectual property enforcement agency, which I think can be called INDIPA. And in that, I think you need to have a proper administrative committee under governing body, which should represent all music and IP owners and creative industries. The enforcement wing of this agency should be separate. This should be recognized by the government as the IP enforcement apex agency in the country. Once you create that kind of an agency, you can form various subcommittees within that agency to ensure that all the IPR owners, artists, lyricists, music composers, etc. are collected there. There's a proper database made of IPR rights, collective database of who are all the owners of various music compositions, various arts, various tribal arts, various folklore. These are all things which are being completely misused internationally. Because if you go to any major jurisdiction in the world, any major metropolis, there will be a small India market there, and you'll see almost every form of our traditional expression, whether it is the geographical indication market, whether it is folk music, whether it is paintings, whether it is meenakari, whether it is, the pashmina, whether any form of traditional expression in India is misused. There's a lot of money which is being lost by our own communities, by our own artists and people. We can actually do a lot by having an IP enforcement agency at the apex level in India, at a central level, not in a state. Every state has a separate. And this should be the common platform for all IPR owners in the country and for people who want to exploit IPRs. So this single platform organization can actually start having negotiations with international bodies which are of a similar nature. For example, Europe has a specific agency which deals with all performing arts and performers. In US has a specific agency which deals with visual arts. This agency should have negotiations with all of them. India is actually a victim of piracy because we other creative content is the highest. Almost all the television channels of our country are available for free in the US and UK. I have watched them myself. I don't think any broadcaster is getting any money from any of these jurisdictions internationally. So I don't know why we are not getting together and putting these as part of bouquets, which are subscription bouquets across the world. Broadcasters need to earn a lot of revenue from these international markets because our Indian diaspora is very, very big. And there are viewers across the world for Indian channels. And if you get together and create this kind of a platform, revenues will increase. It can be trickled down. This agency can be the disbursing agency for all the artists who can be paid on the basis of the downloads which happen on the internet. The collection can be at a centralized level and it can be actually disbursed to all the stakeholders and the IP owners through the agency. The setting up of this agency would also help in negotiation of free trade agreements, because I know as a matter of fact, for example, when the Europe and the Indian FTA is negotiated, there is a lot of demand from the other side to, get recognition for their geographical indications, such as champagne or cheese or any of those. But we don't have the same kind of provisions for protecting our IP owners in our free trade agreements. We need to have that. The negotiation between the governments of the different jurisdictions has to be backed up. Just the way it's backed up by their IP owners from their side, India needs to do it from our side as well. There are a large number of new forms of generation of revenue. The internet has opened up this space in a very big way. Every YouTube download gives money to the copyright owner or to the artist. And according to me, these revenues which are generated from online platforms ought to be collected at a particular centralized manner, and digital marketing of these IP rights needs to be done. For example, it will be very surprising. Even someone like Sotheby's has made its online auction business so big now. They generate $155 million of revenue every year just by online business. So in the same way, we need to have corporates and IP owners supporting the cause of copyright, because I think copyright industry has a huge potential in India and it's totally untapped. I would say that it needs to be tapped. It can be tapped, and at least 10 times more revenue can be got into the Indian economy by creating a centralized IP enforcement agency. I think we don't need to look at the laws. The laws are there. The laws are being interpreted. Courts are protecting rights of IP owners. What is lacking, as I said, is the channel between the huge demand and the huge supply of copyrighted works. With this, I end my keynote address. Thank you so much.
Thank you, Justice Pratibha Singh, for delivering a very insightful keynote address. It was truly enlightening, and I'm sure the participants would have immensely benefited after listening to your observations, and will take back with them valuable knowledge, information, and insights on the current and foreseeable issues and challenges with regard to copyrights in India. We particularly take note of your suggestion for that central enforcement agency, something that FICCI actually has been trying to highlight to authorities and policymakers, and will continue to do so. Ladies and gentlemen, we now move on to the panel discussion, and to take the discussions forward, we have Mr. Kaushik Moitra, partner at Bharucha and Partners, who will be moderating this session. I will invite Kaushik to kindly take the discussion forward.
Thank you everyone. Thank you Dipankar, and thank you FICCI for putting this panel together. We are grateful to Justice Singh for the keynote, and I think that's been the ideal setting for the panel in that sense. And just by way of introduction, I'll just start from the middle. Of course, Justice Singh doesn't need an introduction at all. She's the IP division, one of the judges of the IP division in Delhi, apart from being an accomplished lawyer herself, and a lot of us have had lots of learnings from her in that sense. So thank you for gracing us. Thank you. Dipti, again another old friend, leads Geo on the legal side of things and has led various other digital and non-digital platforms in the past on the legal side. Thank you, Dipti, for coming on. Karan, another person from the bureaucracy, but somebody who's looking at copyright and trade very, very closely at the DPIIT. Thank you, sir. Gowree, part of the bar and accomplished lawyer, both IP, TMT with NDA, and a partner there. And Uday, of course, the standing voice of the Motion Picture Association and the industry itself. Thank you, all of you. I think this is a truly representative panel in that sense, and we take off from what HMJ Singh said, that it has to be, in that sense, a centralized agency. So just to start things off, in that sense, I've tried to kind of divide this into various things, because copyright is essentially has an interdict from revenue, law, policy, technology, and of course thereafter the judicial experience. And as Justice Singh said, that there is the law, there is the judicial expertise, now we need to enforce. So I'm just going to start from the other corner, from Dipti, and I'll start with the most important thing that drives businesses, which is revenue, right? Dipti, my question to you is this, that from a revenue standpoint, and when we have these interdicts, how do you think we can actually squeeze out the market from the illegal revenue that has been created or being earned because of piracy or any sort of infringement of copyright? Over to you.
Thank you. Good morning, everyone. It's a pleasure to be here amongst all and be part of this panel discussion. So before that, ma'am, you really covered and set the context, because it's also an eye-opener for us. And we all as an industry also have been actually fighting this piracy and trying to have the measures to actually curb it, but implementation, there is still lots to be done on that front. Coming on your question about revenues vis-a-vis, piracy has been a real problem for all of us, and along with MPA and other FICCI, other bodies, we have been trying to curb that since last so many years, but there are state also, there is a task force which at the state level is also there, but of course there is a huge requirement from government in terms of support, though laws are there, but implementation is a problem. So as a platform, as a owner of copyright, there is a huge requirement of actually having a negative list, because we all know there are so many pirates. For every release, before every release, there is an operational hazard now that we have to rush to courts and waste courts' time in filing John Doe orders to protect our releases, so that there is, because immediately there are, before the release also there are instances there piracies have happened. Suppose we are sending the film for a international release just before maybe some festival. From there also is there. We do try to watermark, but of course there are at times the pirates find their own ways. So what we are suggesting, that as an industry we need to have a negative list, which we have spoken in the past also. This is not the first time I'm raising this. That we know that there are these negative sites which are there. Government can actually, try to restrict the usage of download, because whatever happens is through VPN. So maybe there is a time has come that we should stop this through VPN access. The download should be stopped through VPN access. It should only happen through proper subscription channels. Also, we have been talking about that there has to be, ASCII can play a big role in this, because there are these advertisers and sponsors who advertise on these websites. So then we need to have a list of those sponsors. We go to them and we of course tell them to stop it, and there should be some enforcement help in curbing that through those sponsors also, because the moment you stop the revenues from those sites, they will stop, or maybe at least their revenue loss will be there, which revenues can then come to us. Also, I would say that it is, ma'am, your suggestion, there are small this collecting agencies which are there, but there is no one-stop agency which at an apex body, which you have really rightly said that we should have. So as a collective effort, of course, the industry need to come together and work towards it, and we will of course talk from, understand from Karan that as a government also what we can take help from them. Thank you.
Right. So thank you for those thoughts, Dipti. And somewhere in your, while you were speaking, you spoke about technology. And I, in my initial comments, had said technology in that sense is the next interdict. So I'll just come this side now. I'll go to Uday. Right? Uday, you represent an international body which has been using technology for a long period of time to combat copyright. And we would love to learn from the global experience and your experience of what you suggest is the next interdict, because to stop revenue from illegal apps or infringement, we need technological support. So over to you.
Thank you, Kaushik. Let me begin by again thanking Justice Pratibha Singh for a wonderful, insightful session, and taking a cue from that. Content theft, as we like to call it, is actually an economic offense which undermines the revenues of the creators, the producers, the investors, and even the consumers are exposed to harms such as malware, ransomware. In fact, there was a session yesterday, they talked about how, identity theft and fraud also happens through some of these sites. So this has been an ongoing problem. Actually, as per a Erdato study which came out in 2020, the losses to the M&E sector are in the region of $2.8 billion, which is quite substantial. Coming to the actual issues that we think that we can actually tweak in the Copyright Act in the growing digital new ecosystem, is one of the things is that while we have the law which takes care of primary liability, we are not looking at secondary liability because there's a slew of new providers that have come into the ecosystem. Content delivery networks, hosting services, domain name service providers, search engines. There's a whole new, as we move from analog to digital, there's been this big change that we have seen. So when you have this, there is a primary liability, but not everywhere there could be an actual notice or a constructive notice that could be served on any one of them, and what action has to be taken. That there has to be some level of, there's a neutral or a passive intermediary versus an active intermediary. So we need to have some kind of recognition of that and establish clarity on secondary liability. The second thing which also which came out of one of ma'am's judgments is there's a very important need that the platforms, especially in the B2B space, deal with known commercial entities. That's why we recommend know your business customer provisions, which actually, and anything we do, we give our identity, Aadhaar card, this card, that card, and most of these sites, if you see, they don't even have a proper address, they don't have a proper location. So how are they getting registered? There has to be some kind of a KYBC, which kind of makes that easier for for enforcement. The third angle would be from piracy apps. We just saw in Singapore, we've seen how the Copyright Act was amended to have civil and criminal liabilities against piracy apps which are dedicated to piracy. I think there has to be a lot more to be done to be able to strengthen us in that area. Fortunately, we've sent all these recommendations already to DPIIT, and we got a note. Thank you for that, saying that we're actively looking into these areas. The third is, of course, to strengthen the Act further against copyright infringements. As we've seen, a lot of these people are dipping into the pockets of the creators and taking the money, sometimes many a time before we can actually even make the first dollar, because they steal it over the opening weekend. So we've also seen yesterday the INB secretary in his inaugural address saying that in the winter session, hopefully, we will see the cinematograph bill go through with the anti-camcording provisions in it. So that would be another shot in the arm which could help us. If you look at the TPMs specifically, as you said, that in a world where we have SVOD, TVOD, AVOD, and streaming services, while we have addressed in the last amendments, we have addressed the copy control issues, we still have to look in the streaming world at access control issues and circumvention of hackers' tools who actually go past your DRM and hack into your system. So we have been recommending that we strengthen, when we signed the WCT and WBPT, we have implemented this, but I think looking at the streaming world, the access control, and having strong provisions against circumvention devices is another deterring effect that would be valuable. So broadly, these are the areas that we are looking at, and as ma'am rightly said, we are such an active producing nation across the world. One of the lowest hanging fruits, I would say, which you saw unanimity in the earlier roundtables that we had together, is the term of protection, if we could increase it in line with the other European countries, so that our creators in this country also get the same protection term up to 70 years. In fact, New Zealand recently amended their act to increase to 70 years with the UK FTA. So my recommendation would be that if we look at these 4 or 5 correctional tweaking of the act, I think it would definitely send a message that that 2.8 billion which is being leaked or being stolen is something that we could get some of it back into the industry. So
right. Thank you, Uday, and that was insightful. Now, moving on from revenue, technology, let's now move on to law and policy. Right, and I'll, before I come to Karan and then allow Justice Singh to kind of tell us more about the judicial experience, I'd like Gowree to decode for the audience here in very, very lucid terms what is the law around copyright and how it's being implemented in a very, very short span of time, as we discussed.
I don't mind doing that, but before that, I just want to sort of add a particular perspective to the table, to bring everything together. I think, whenever we are looking at current issues, we are talking about Web 2.0, right? And I think we are moving on to Web 3, Metaverse, and all the newer technologies. So every time you saw the progress in the technology, you saw the issue has only heightened.
Sure.
Right? And of course, when we talk about, you mentioned about Copyright Act, of course, there are civil remedies, criminal remedies. The audience is not, too many lawyers here, or I don't think there are lawyers. There are, sort of, other professionals. So, we were just deliberating, let's not become too legalistic, but I'm simply saying civil and criminal remedies are available. But I think what aspects I feel on the copyright law overall and policy, I think I just echo, Justice Pratibha Singh's sort of solutions. And when we are moving to next, level, I think the identification of the rights, correct? So under the Copyright Act, when you go for enforcement, now I'm just going to,
Sure.
just to, take your point and to put it in the context, right? Any enforcement that you go, when you go before the court, you have to establish that you have a right, correct? So that is where, we are currently struggling, at least, for the old, sort of music or, remake rights and all of that. So unless you are able to establish, it becomes difficult for the court to, sort of grant that right. So I think there are now technologies such as blockchain and the like, where can we establish a registry through blockchain where, your rights are coded. Even when, multiple rights get created, I'm sure, ma'am would have received a lot of, actions for, who owns the remake rights. So that becomes a question mark, right? Because in India, interestingly, there are so many languages.
Absolutely.
And we have seen contractual confusion, who holds this, Hindi remake or a Tamil remake and the like. And, those issues need to be addressed, to establish the right. I think the next point, when it comes from an enforcement perspective, right? Ultimately, when you get an order, where do you go enforce, right? So when you talk about criminal liability, unfortunately, the identification or tracing, that becomes a problem. So when you say criminal, that means you're looking for some punishment. To put it very simply, I'm just, keeping very simple for the audience. And in civil, you're looking for injunctive remedies or damages,
Revenue,
right? So when you talk about criminal remedies, honestly, to trace most of these people, we have seen it's absolutely getting difficult. Cyber cells are struggling. Right, so can the industry come together to figure things out for them, right? I remember that when I used to actively handle cyber law cases, which I do today also, but you have to actually sit with the cyber police, figure things out. It is getting difficult. And most of these activities are happening from international jurisdictions, right?
Yeah.
So penalizing an offender is not really a solution. That is, I'm noticing. And therefore, the threat of penalty also is not working. Right, so a criminal remedy somewhere, is it really working is the question, right? Maybe it will work at a local level, to trace. And we saw yesterday, I think Netflix had, had that particular, sort of thing on cybercrime, right?
Yeah.
So I think more needs to be done where, industry, technology, we have tremendous, IT industry. Can the industry help the cyber police, to do that? So that is one area I feel it is not helping because we are not able to trace the criminals. Coming to the civil remedies now, I think, again, damages, is it a deterrent in Indian context? Unfortunately, it has not, but we'll need to see now, with the IP, codes getting established and all that, I'm sure, that can get a deterrent. But I think the immediate relief, right? Because here, as Dipti said, the immediate injunctive relief is where it really, is important. And in that context, I think the courts are doing tremendously great, right? The blocking of the IPs and all that. I don't think, we are falling short on that. What the gap I feel today, right, is the creative community. See, big companies can go to court every day. Right? What we are struggling here, and especially when the creators are going direct to the market through social media, through NFTs, when they're going direct to the market, and if their rights are infringed, right? As ma'am said, you need a nodal agency. For them, for individuals to run to court, it is going to be expensive, right? To get those civil remedies. As I said, criminal remedies are not currently that effective. So those type of remedies where, which is more of a without going to court, can we, get them, individuals, those remedies, where their rights are recognized through the right management system, or rather whatever the registry we create, and therefore a quick remedy, especially in the digital context, it's extremely important, right? So I'm just trying to sort of divide where we land from establishment to enforcement, and I completely echo what has been said. And the last point on this ASCII, which Dipti you mentioned, in fact we had made a representation to ASCII to look into this, and maybe one more dialogue we could have on this advertising support. We could probably do that as well. One other aspect is, I don't know how much it is going to help, because I've not seen too much criminal thing, but under PMLA, which is the Prevention of Money Laundering Act,
it's a proceed of crime.
Copyright, is one of the scheduled offenses, right? Copyright infringement. So can the police take something, additional steps basis that? But again, unless you trace, what action can you take, right? So it comes back to the tracing aspect. So yeah, I'll stop here for the time.
Right. Thank you, Gowree. And now I'm going to put Karan in a very tight spot. And that's the best part to do in such places, and sometimes, it's the regulator and the policy guy. Karan, you've heard the industry. You've heard the industry association. You've heard the practitioner. DPIIT, intersection of law, policy, trade. What are we doing to ensure that all this is balanced out to the extent we can, and create that enabling ecosystem which everybody's been the common thread, number one, and possibly figure out a intersection of the various acts, both on the commercial, on the revenue side of things, and on the enforcement side of things, to create an ecosystem where everybody is sensitized, and we can generate the maximum amount of effect on ground. Over to you.
Thank you, Kaushik. And first of all, I think I'd like to take the opportunity to thank the organizers, and thanks FICCI for organizing this and for assembling such a esteemed panel here, and also thank ma'am for this insightful presentation. I think before I sort of come over to the actual issue and question that you asked, I think listening to all these viewpoints, I felt maybe something that was a bit addressed by Gowree, but something I think I wanted to address as well is that technology, or the topic per se, the digital age, is one of the key aspects of technology that is also an enabler. I think while we've harped on the fact that technology has created a lot of challenges, has led to a lot of copyright infringement, piracy, and so on, in my perspective, it also, as a consumer, it is also a significant enabler, which has allowed significantly quick reproduction and distribution of copyrighted works. And I think that's where ma'am's perspective on how this presents a wonderful opportunity for the industry at large to grow and sort of assume massive proportions, which we are very much capable of. I think ma'am presented a lot of very cogent and remarkable statistics, something which was an eye-opener. I remember reading that in countries like, for instance, US and UK, the creative industries themselves constitute around 11% of GDP, for instance, in the US, 5% plus in UK and the EU region, while I think what ma'am indicated was even sub 1% in the Indian context, I think 0.58% if I remember correctly. I think this poses a significant question as to why we have not been able to generate enough revenue. While infringement, copyright piracy continues to be important issues, but I think the key aspect also is on how to make the chunk size bigger. I think from where we sit and the perspective that we get from the industry, there are several stakeholders, there are multiple players. And each one of them has their grievances, each one of them has their demands. And essentially what we find is that most of the times those demands are at a conflicting nature. While you would have the artists and the creators looking to seek a larger pie, larger size of revenue, of royalties from exploitation of their works, the industry would also want to continue making sure that the producers and the creators have actually, those who have put in the revenue are able to utilize that. I think that's where ma'am did touch a very significant point of looking at coming together of all players and establishing something like a single window system, a common platform, which enables users to access works easily. I think it is the need of the hour that we all together, along with DPIIT and the government, to enable this framework and put in place a mechanism which allows users to easily access works. I think this demand and supply gap has for too long led to difficulties for users to actually, even for well-meaning users, to pay the adequate royalties and remuneration to the industry. The second point which I think wanted to touch upon was something which I think ma'am also highlighted, is the fact that I think all of us in the room have some point in time consumed pirated content. I think for two reasons. A, it could be for the fact that it's something which is, for which we do not want to pay. But something I think which we are trying to address from our perspective is also the sensitization and awareness perspective. There are many people who ignorantly or without really understanding the implications of what they are doing, enter into consumption of pirated content. I would remember my younger days when this perspective was something which I never had, and likewise when you interact with a lot of young population or for instance friends and family, you find that that perspective is missing. So what we are trying to do from DPIIT and from CPAM is trying to create that sensitization, that awareness, and trying to create an outreach perspective that what you are doing is actually not just hurting the rights of the copyright owners or creators, but the larger national interest in its bigger sense, and is actually creating a demand for a lot of pirated content to be generated. So while there is a demand, the supply continues to exist. We live in a simple demand-supply economics, and that is something that we are trying to drill down through our outreach programs. On the enforcement perspective also, I think while there is a need of the hour to look at stronger enforcement mechanisms, to also strengthen the laws, which I think is quite commonly understood, given the fact that so much has happened over the last 10 years, that the Copyright Act, when it was last amended in 2012, would naturally need a review, and that's what the department is undertaking currently. And we have received several suggestions, feedbacks from the industry. I think what Uday also alluded to is something that we are considering on looking at possibly strengthening the TPM measures, on sort of anti-device measures, and likewise on the access control system. But while we are strengthening the laws, I think what we are also looking at is, once again, a key sensitization and awareness drive for our law enforcement agencies. It is, while in cyber cells, for instance, in bigger stations like Delhi and Mumbai would be well aware, I think our approach has been to go down to our tier 2 and tier 3 cities at group B and group C level, actually make efforts to bring on board your local law enforcement agencies, because they are the ones who are actually going to implement the law at the final stage. So it's that link that we're trying to sort of strengthen, bring more people on board. We have carried over 100 sensitization programs and training exercises with different law enforcement agencies, including police, including border enforcement agencies, as well as in several judicial academies. Not all judges are as well aware and well versed with the IP law as ma'am is, and we are lucky to have her here. But this has been a conscious effort on our part over the last 3-4 years, ever since the national IPR policy came into being. On some of the points that Kaushik you raised, I think it's a sort of always, when you are into the policy making and law making, it's always a difficult act to sort of balance everyone's interest, and you end up sort of offending one interest group over the other in whichever manner you may try your level best. I think it's an important issue. Copyright infringement, copyright piracy is an important issue. We see that the law currently is quite adequate in several areas. There might be some minor changes, minor tweakings that may be required over a period of time. What is really the need of the hour is a stronger enforcement and implementation mechanism. We've been studying the model on national enforcement agencies across the globe. Different countries follow different models. There are several coordinating mechanisms that have been put in place by several EU member countries, likewise by the US. But we have to also understand that India is a large geography. India is a large country. We are 27 states all put together to form one country, and each state, or while there would be national priorities, national perspectives, likewise there are always local priorities and local perspectives as well. So given that fact, this is again an ongoing consultation, an ongoing exercise. It is very much in line with the whole of the government approach, which our Honorable Prime Minister always also emphasizes on. There are several stakeholders, several important ministries, such as the Information Ministry and Broadcasting, the Ministry of Home Affairs, and likewise the Ministry of Education, which have been brought on board. But it would sort of suffice for me to say that this is again something which is sort of in the pipeline and possibly on the Hon'ble in a few years' time. So I think with this I will pause here and...
Thanks, Karan. And before we come to Justice Singh, Justice Singh I have a question for her, and I think Gowree has something to add. Just a moment.
Yeah, I just you mentioned about the various laws, I think, and you mentioned about the intermediary issues, etc. I think the government is looking at the Digital India Act in toto. And if DPIIT wants to revisit the Copyright Act also in that context, I'm not getting into the royalty aspect here. I'm just focusing myself on piracy. So I think there, if you are able to sort of look at holistically between the Digital India Act and the Copyright Act, and how can they talk to each other in terms of simple enforcement that ma'am mentioned, because the anxiety today is everybody has to rush to court. Can there be a simpler mechanism between these two acts one can create? That was my limited point.
Right. Thank you.
Just to add to what Gowree said, it will be also important because as we are going ahead in digital age, with the new technology advent, the laws also need to recognize and regulate them, because that's also important in NFTs, your bitcoins. We are in metaverse, again we are creating clones, so that also needs to be recognized and regulated also.
Of course.
See if we can think of something on those lines also.
So thank you. Now Justice Singh, now you possibly the only person on this panel who has been on both sides. You've been a practitioner for the longest time, and now you're on the IP division, and you continue to be a practitioner in your heart in that sense. Can you just you've heard everything, you've heard everybody. If you could just put together your thoughts on how life has changed from broadcasting. You spoke about that, touched upon that when you spoke there, to now when it's become the digital age, and how the judicial experience in that sense has been, both at your level at the High Court and also at the downstream level, because it ultimately builds up there. So we'll be grateful if you could put some light on that.
I will need an hour to speak on that.
May I dare only...
No, I'm just joking.
We'll have a separate session on this. We'll go back to FICCI on this probably at some point.
Let me give you 3 examples, and then I'll take it on that context. From my professional life as a practitioner, and why I actually have suggested the setting up of this agency. And this is an amalgam of my experience both as a practitioner and as a judge. So these 3 examples are as under. First example, there was a small FMCG company who wanted to make an advertising jingle. And they said, we want to purchase the rights for this jingle, for the music that we want to use, and we'll be kind of, tweaking it a bit, and we want to use it for this jingle. I told my office to look and find out the way in which we can get them a license. And believe you me, I couldn't. Because you go to PPL, you go to IPRS, you go to the cinematograph owner, you go to the sound recording owner. No one knows who can give that license and what it is going to cost. So that company actually gave up that particular jingle itself. There was a second instance where there was a book in Hindi, which was published sometime in 60s, 70s. And it was a well-read book. And there was a South Indian publisher who wanted to translate it into South Indian languages. The author was dead. They wanted to buy the copyright, translation copyright. We couldn't trace the heirs. Look at our country, despite all the, efforts that we had, we couldn't do it. Let me now tell you as a judge, take any, well-known, brand or business in this country. A fake website is set up. They offer distributorships, they offer franchisees, they offer jobs. Several 100,000 people pay 3,000 rupees, 5,000 rupees, 10,000 rupees to get a distributorship or a job. All that money is collected in different bank accounts. Right? So we have a domain name registrar, we have a KBYC for that, which is all privacy protected. No one can make out who has registered that domain name. There are multiple mobile numbers which are given as the identity for the bank accounts. There are Aadhaar cards which are forged, which are given. The brand owner is suffering because hundreds of people are writing complaints to him that we paid you money for giving a job, but you didn't. Cyber police can't do anything because the banks are not freezing. The money is deposited in 1 minute and the next 10 minutes the money is withdrawn. We are dealing with hundreds of cases like this in the courts. So all that was needed was some agency which could say, this is a brand owner which is a well-known mark. Please stop this website. Don't allow this website to be registered. The translation person can go up to this agency and say, look, I cannot trace the owner. I'm willing to deposit some money. Whenever the owner or the heirs are traced, they can take the money. So there should be a standard rack rate which is there for a translation to be published. For an advertising jingle, again, a standard rate can be fixed. I remember the entire dispute between FM channels and copyright owners. It could have been resolved sitting across the table so easily. And we went through so many years of litigation in that. So all that I'm saying is, I understand what Karan is saying, that they have to coordinate with states because law and order is a state subject. But IPR is a central subject. So the agency, the Indian IP agency, which I call it as INDIPA, should be the agency which should have the power to coordinate and to tell the law enforcement that this is what needs to be done. There should be 50 conference rooms in that agency where people from different industries can sit down and negotiate their agreements.
Of course.
There should be, let us look at, for example, Kanjivaram saris, Banaras saris. So many of these saris get made not from the source and sold on e-commerce platforms, sold internationally, Kolhapuri chappals, art, any kind of art, they'll be sold openly on all the e-commerce platforms. And we don't know if they are going to those relevant communities at all. So I think the time has come. My experience on the bench tells me that courts can only walk this far. We can't go beyond the point. So therefore, the requirement of the common platform, call it anything, but this should be at a central federal level, not at the state level. State level is not going to help because it is impossible to coordinate between state, police, etc. So I think the common platform has to be set up. Please make the blueprint of it. Create a governing body, create administrative committees, create subcommittees, get everyone who has any IP in this country on that platform, create databases, create royalty regimes, and that's the only way you create a vibrant IP system in this country. If you don't do that, we are in for a long haul the way we are already going. We'll keep stuttering, stammering, limping, but you need to do something very surgical to bring the change. Thank you.
Grateful for that. I think we have about 30 seconds left, so I think we'll take that one question and one. How many can I take, Dipankar? Two in all. So I'll take the lady there and I'll take the gentleman here. I'm sorry. Please go on, sir.
I am a writer, producer, director. My question is, can we not have a QR code for everything that is created artistically, which is connected to the board, like every script that is done and sent to SWA has a QR code. So why not every piece of art? I mean every, whether it's art in drawing form or anything. And we are digital today. Can it not be put up onto a digital system with a QR code which can have the details of the ownership? Is that possible to do?
I think that's a great suggestion, and that actually speaks to what Justice Singh is saying, centralize the whole thing. So, I mean, if you want to react.
I think that could be one of the solutions, but let this agency who has to look at IP enforcement look at it as a solution.
Right. Sir.
My question is to Hon'ble Justice. I've got certain copyrights to certain movies which are in public domain now. Okay, and to name a few, Baiju Bawra and Gunjuthi Shenai and all that. And since as per the law they are in public domain, how come the literary rights owner are still getting paid for it? The songs and the lyrics and all that. And
Please take it out.
no, but it was made for the film, right? Okay.
So I think there is a difference, right? There are when you say a film, there are multiple rights holders in that. So the film, when published, from that day you calculate the copyright, which is understood. But the underlying rights, which still exist, and their authors are still alive, or or 60 years have not passed since their demise, the copyright still continues for the underlying works. That's a simple answer I will give, and maybe we can discuss it more later.
Right. Secondly, I would like to ask, since these movies are in public domain and people are putting up these movies on various YouTube channels, how come they are monetizing it?
So that's a much larger issue. So I think I'll allow that to be, once Gowree gets down from the stage, you can chat up with her outside, because that's going to be a larger issue. So I'm going to end this.
One last question.
Sir, I'm so sorry, not anymore.
Will I be eligible for royalty for my works which are now in public domain?
Gowree, please. I think that's something. See,
honestly, as lawyers, unless you know specific facts, we are, honestly, I don't want to, say something in the public, which may be not construed appropriately. So unless you know specific facts, it's inappropriate for me to, answer that. Sorry.
So there'll be a privileged communication at some point. At that note, thank you, FICCI. Thank you to the sponsors. Thank you for coming all this way. Justice Singh, thank you very much. Dipti, Karan, Gowree, Uday, thank you Dipankar for putting this together, and I hope some of the questions everybody had were answered. This is a very large topic, and we are all available. Please reach out. We'll try to help as much as we can. Thank you once again.
Thank you. And also from FICCI, a big thank you to the audience for your patient hearing, attending in such large numbers. And I hope you will continue to engage with FICCI programs in the future. Thank you so much.